My name is Teresa Flores. I'm a supervising attorney at NIJC on the VAWA New Visa Pro Bono project, and I'll let my colleague introduce herself.
Great. Hi, I'm Graciela Ruiz, and I'm the paralegal for the VAWA U Visa Pro Bono project.
So the presentation for today is about representing immigrant survivors of domestic violence and covering VAWA. But before going in depth about the materials, just share a little bit about NIJC. We are a nonprofit organization. We have several offices. We all work at the Chicago office, but we do have one in Indiana, in San Diego, and in Washington, D.C. And what we do is we provide direct legal services and also federal litigation to immigrants, refugees, and asylum seekers. We've been around for over 3 decades, and one of the things that's unique about our organization is our ability to blend the individual client advocacy with the broad-based systemic change. For the agenda today, we'll be discussing VAWA. We'll talk a little bit about NIJC's Pro Bono project. We'll go into an overview on the family-based immigration, then going into VAWA. Graciela is going to provide some tips on working with clients who are survivors of domestic violence. And then we'll talk more about what it means to prepare a case, what the process looks like, and then at the end, provide some resources and our contact information. All right. So our pro bono project, the way that it works is usually an immigrant will reach out to NIJC looking for an attorney to see if there's any forms of relief available for them. Our staff conduct an in-depth intake with them to assess the case and determine if they have a possible claim. And if they do, we'll accept the case. NIJC signs the retainers with the client, and then we begin the work to look for any pro bono placement. So that's where you all might come in. So the pro bono project, the pro bono attorney team would then accept the case. NIJC remains of counsel on the case, and we would provide technical assistance, support with document reviews, and just any support that's needed. Especially now, we would be providing any updates if there's any changes in the law that would affect the client. And so what it ends up looking like is there are certain responsibilities that we will have, responsibilities that the pro bono attorney will have, and then responsibilities that the client will have. So like I mentioned, we would provide the general trainings. For example, this would be one of the trainings. We'd provide technical assistance. So pro bonos would reach out to us and say, this issue came up, how should we navigate it? And our team would help assess the case and just talk through it. We have sample briefs that we would provide, and we would provide any policy updates. So just as an example, last week for some of our pro bonos, we had a training about how to counsel clients during uncertain times. And as mentioned, we would remain of counsel. So at no point would the pro bono attorney feel like they are on their own now to navigate this possibly confusing aspect. But what we do ask for the pro bonos is that they would be the ones that are in charge of case management. So any contact with the client, that would be the pro bono directly with the client. Pro bonos are the ones that would prepare the case, make sure that they're maintaining communication even after the application is filed. And pro bonos would be the ones that would provide any interpreters if interpreters are needed. And then if the client happens to, if the client is, depending on what application they're filing, the pro bono attorney would represent them either before immigration court or with USCIS, which is the agency that processes the VAWA applications. Then with the clients would be telling their story truthfully. They would be sure to communicate with the pro bonos and notify of any changes that would happen, such as if they moved, if they had any arrests, if they got remarried, they would be sure to communicate that with the pro bono. All right, any questions on the pro bono? Okay, and we'll go more into details, so maybe I'm sure things will make more sense. But before we dive into what VAWA is and how that all works out, we should go over what the family-based immigration process looks like. And so oftentimes when we're evaluating cases, we want to know what is someone's immigration status. And so an individual could be a US citizen, they could be a lawful permanent resident, they could be considered an immigrant status, and that means that they have permission to be in the US for an indefinite period, so such as asylees or refugees. And then there's non-immigrant status visa holders, so that would be like tourists or U visa holders, deferred action, certain work visas, those would be temporary. And then if someone does not have any of those visas or status, then they would be considered an undocumented immigrant. So with the family-based process, a US citizen or a lawful permanent resident is able to petition for their family member. And so for the purposes of this specific form of relief, it's a two-step process essentially. So the US citizen or the legal permanent resident family member would file the petition. That's the first step. Then the second step is that the immigrant would apply for lawful permanent residence, and that would sort of determine based on their immigration history, if in some certain circumstances they could apply within the United States. But if not, then they would have to return back to home country and apply from abroad. And generally for our pro bonos, if that's the case, we wouldn't assign those cases. And we would let you all know if the person is eligible to apply within the United States or not. So we'll go into depth with the first step, which is the family-based petition. So the US citizen or lawful permanent resident family member is going to file Form I-130. And this provides sort of a breakdown because there is a difference between who is filing. So if it's a US citizen that's filing, they're able to petition for their parents, their spouse, children, which for immigration purposes is anyone that's under 21 years old and unmarried. They could petition for sons or daughters that are 21 years old or older, and it can be married or unmarried. And they can also petition for their siblings. For legal permanent residents, they can petition for their spouses, their children, or sons and daughters. But all this to say that in order to file this application, it must be a citizen or lawful permanent resident that is filing it. And that person would be referred as the petitioner in this case. And this will make more sense in a couple slides, but there are certain family members that you'll see, note that they're considered immediate relatives. So with immigration, it's broken down into which family members are considered as immediate relatives and which ones are considered as falling under a preference category. Folks that are immediate relatives, they don't have to wait between filing a family-based petition and when they can adjust status, because that means that the visa is available now for them. So that would be parents, spouses, and unmarried children under the age of 21. If they file a petition, the visa is available now. But for anyone else, or if the petitioner is a legal permanent resident, then there would be sort of this waiting time. And usually when you file the Form I-130, you'd receive a receipt notice and it will have a priority date on there. And that sort of indicates what your place in line is. So with the visa bulletin, they break it down into different categories. So it'll say the first preference category is going to be unmarried sons and daughters of US citizens. The second category is sort of broken up into an A and B preference. So it'll be A is spouses and minor unmarried children of lawful permanent residents, and B is unmarried sons and daughters of lawful permanent residents. Then the third category is going to be married sons and daughters of US citizens. And the fourth one is brothers and sisters of US citizens. So this doesn't really mean anything right now, but in the next slide, we'll see why it matters. So it doesn't really tell you, this is an excerpt from the USCIS, or sorry, from the Visa Bulletin site, which is updated monthly and will say what the current processing is or what the priority date is. And so the first column there goes into what the different preference categories is. And then it's broken up into different countries. These are the countries where there's the highest number of folks filing in petitions. So it'll be China, India, Mexico, and the Philippines. If you're not from any of those countries, then you would be in the second column. So it's like any other country. So just to get an idea then, for example, if you are in the, like, let's say I'm petitioning for my brother, I'm a US citizen, and my brother is from the Philippines, then we would look at the F4 category for the Philippines, and it looks like they're processing petitions right now from October 15, 2004. So it'd be at least a 21 year-ish wait. So this is why we bring up that there could be a long waiting period. We would obviously tell pro bonos if there's a situation where there's not a visa available, then we might not be able to file one portion, but maybe the other portion, but that'll make more sense as we go along. So the second step, yes. They do actually, but sometimes they change in odd ways. So I don't know if it was last month we were looking at it, and one of them, I think it might have been the F2A category, which is spouses and minor children. Oh, no, sorry. The first category, the unmarried sons and daughters of US citizens. It was saying like that it was current. And now if we're looking at it, it's not current. So sometimes they do revert back. So they can change. We would obviously check at the time of filing, we would check what is the priority date. But yeah, unfortunately, sometimes it goes forward, sometimes it goes backward. It's right. Right, yeah. Yeah, but that is a good question. All right, so assuming that the priority date is available or that the applicant or beneficiary, which would be the family member of the US citizen or lawful permanent resident, if they're an immediate relative, then they could potentially file an application for adjustment of status, and that's done through Form I-485. And so if the individual is able to adjust within the United States, then they would have an interview here. But if they're not able to adjust, then like I mentioned earlier, they would have to return back to their home country to do consular processing abroad. Right now, we're currently not taking those kinds of cases. So for the purposes of this training, if someone is able to adjust, it would be within the United States. Any questions on anything so far before going into the Violence Against Women Act? Yeah. Yeah, so the question is, what would happen if the petitioner, so the family member that's in this scenario is a lawful permanent resident, if while the application is pending, they become a US citizen, does that change their preference category? And Trisha, correct me if I'm wrong, but it would change their preference category. And it also works the other way though too. So let's say that they are an unmarried child, an unmarried son or daughter of an LPR, a legal permanent resident, and they're in that 2A category. If they were to get married, then they would go into the 2B category, and so the wait might be longer. so that it can work sort of both ways. Yeah. All right, so we'll go into the Violence Against Women Act. And then before Graciela goes into her portion, I'll make sure there's time for questions because I know this can be a little bit, this is a lot of information. So just a little context on the Violence Against Women Act. This was a law that was signed back in 1994 by President Clinton. And since then, it has been amended in 2000, 2005, and 2013. And what it essentially does is provide, there's provisions in this act that allow for immigrants to be able to gain lawful status without having to rely on their abusive US citizen or lawful permanent resident spouse, parent, or child. When someone is able to apply for VAWA, they would be called the self-petitioner. And so a self-petitioner is anyone that meets any of these categories. And so most commonly what we think of is, oh, they're an abused spouse of a US citizen or lawful permanent resident. And that is commonly what we sometimes see with our clients. But they could also be the non-abused spouse of US citizens or lawful permanent residents whose children were abused by a US citizen or lawful permanent resident. And those children don't have to be necessarily children in common that they have. But as long as the self-petitioner is the parent of that child, then they could be eligible to apply. Then there's also abused children, which just, again, they have to meet the definition of what is a child under the INA. And so under 21, unmarried. But if they're a child of a US citizen or lawful permanent resident and they've been abused, then they could apply. And with one of the amendments in the VAWA Act that came out in 2005, it did sort of change it where a child, if they are the self-petitioner, they would be able to apply, and they have up until the age of 25 to apply. So the abuse would have had to been before they were 21, but they have up until they're 25 to apply, as long as the reason for the delay is related to the domestic violence or the abuse. Then another thing that was changed in the 2005 amendment, sometimes we see folks that, or there's individuals who they think or believe that they are married to somebody, but later it comes out that they were actually not legally married. Perhaps the abuser never divorced, or was, perhaps they're still married. And so what this added was that an abused intended spouse could still apply. So as long as they did intend to enter this marriage in good faith, that would still qualify them to apply. And then lastly, another addition was abused parents of US citizen children. So, but specifically they have to be US citizen children and not lawful permanent residents. What the self-petitioner would have to show is the status of the abuser. So they'd have to show that the abuser is a citizen or a lawful permanent resident. If this is based off of a marriage, then they would have to show that they were legally married and that it was a good faith marriage. Then they would have to show that there was battery or extreme cruelty, which is a legal term. And we will go more in detail as to what everything means and how to gather evidence for each requirement, but just as an overview. Under the battery extreme cruelty, you do have to show that you lived with the abuser, that you live in the United States. And then lastly, because this is a discretionary form of relief, you would show that you've had good moral character for at least 3 years prior to submitting the application. But again, we'll go more into details later on as to exactly how you prove any of these. So the first one is legal and good faith marriage. So as mentioned, you have to show that you were legally married, and the validity of the marriage is determined by the jurisdiction where the marriage is performed or celebrated. So the clients might be here in Illinois, the client might be here in Illinois, but perhaps they got married in Texas. As long as Texas recognizes that marriage, then and it's considered a legal marriage, then it would still qualify. The only exception then, when in terms of demonstrating that you were legally married, was, as I mentioned, if there was polygamy or bigamy before, and so they weren't actually legally married. But you'd have to show that you did enter this marriage in good faith and you intended to be married. And basically what immigration is looking for here is that the applicant intended to establish a life together at the time of marriage. And they're concerned about immigration fraud. So that's why sort of they're really honing in on making sure that it's either legal marriage or that it was in good faith. Oftentimes we get questions, there's scenarios that arise with folks that are trying to apply for VAWA. We refer to them as like the 3 Ds of VAWA, and it's divorce, death, or deportation. So for example, if the US citizen abuser passed away, then the VAWA self-petitioner is still able to apply. There is a requirement, though, that they are applying within 2 years of that death. And so we would let any pro bonos know there's this deadline beforehand, just so that anyone's aware. And the same also applies for divorce. Oftentimes our clients want to divorce their abusers. And it's a question that if anyone takes a case and the survivor is still married, they will likely ask you, can I get divorced? And so they can, but that application has to be filed within 2 years of the divorce. And another thing to note, though, is that the self-petitioner is not able to get married until the VAWA petition is approved. And then the last one is deportation. So if the abuser was a lawful permanent resident and they're deported, if the deportation is connected with the domestic violence, then the survivor would still be able to apply as long as it's within that 2-year time frame. So next is the battery or extreme cruelty aspect. So this is a very technical term that immigration uses to define what is basically the harm that the applicant suffers. And so it can be acts or threatened acts of violence. It could be forceful detention. It can be any physical or mental or emotional injuries that someone suffers. And Graciela will talk a little bit more about what that necessarily looks like or how that plays out with their clients. And additionally, it can include other tactics or incidents too that maybe by themselves don't seem like violence or threats of violence, but that overall it might demonstrate a pattern of violence. So those are ways that you could demonstrate what is battery or extreme cruelty. And then one of the last things is good moral character. And so our clients have to demonstrate that they have had good moral character for at least 3 years prior to filing the self-petition. Good moral character, basically, they can't have any serious crimes or immigration violations. And so there are certain bars, so, and we'll talk more about it, but for example, if a client has like an aggravated felony, or if they have like a persecutor bar, that could potentially bar them from applying. But there are certain waivers and exceptions to good moral character, and it would just sort of depend on the case. But if we, when we meet with the client, if we sort of identify that there might be any issues in the case, we would let the pro bonos know in advance. The standard of proof when we are submitting these applications is any credible evidence. And so that will really make more sense later on when we talk about what type of evidence can be obtained. But just notes, any credible evidence. And one of the things that our clients are sometimes concerned with is sort of this confidentiality. Clients will sometimes be hesitant to apply because they might be concerned that their abuser is going to report them to immigration, or they might be afraid that immigration might tell their abuser that they're applying for this form of relief. And so there are provisions in the INA and in the CFR that sort of protect victims from this. So it does state that the Department of Homeland Security is not able to provide any of the information. So they couldn't just call the abuser and be like, hey, your wife is applying for VAWA. They're not allowed to do that. And additionally, let's say the abuser does call immigration to say like, this person has no status and they're here, I know they're applying. The rules do state that DHS they're not able to make any decision just based off of the information from the abuser. They have to review the entire application. So the reason why someone would want to apply for VAWA is because if they apply, they would obtain what's called deferred action. And this basically, it's not any type of status, as we mentioned before, it's not an immigrant visa status, but what it means is it gives them like low priority from removal. And in that sense, there's sort of a protection there. They would also be given an employment authorization document, which would allow them to legally work in the United States. And for many of our clients, this is generally a huge form of relief for them, just because they've gone so long, sometimes with depending on their abuser. So allowing them to work can help them sometimes leave the situations that they're in. And if the applicant has children, whether in the US or abroad, they could be included in the application also. And then lastly, if eligible, they could potentially apply for adjustment of status and obtain their lawful permanent residence, and then in the future, citizenship. With the adjustment of status, in order to apply for that, the requirement is that they have an approved VAWA self-petition. That one is the form I-360. There are some instances where a person can do both at the same time. So they can file for the VAWA and then also file for their adjustment of status. We, again, would let pro bonos know if someone is able to do that. If they are applying, they would have to have a current priority date or be the immediate relative of the abuser. So the I-360 form basically takes the place of the initial family petition that we mentioned earlier. And that's why that whole chart with the relatives, that's why that would sort of make sense for this. And so we would check to make sure that the visa is available now and that they're eligible. We would make sure that they're admissible so that there aren't any issues that perhaps immigration might deny their application. We would screen for that. And then again, this is a discretionary form of relief. And so we would want to make sure that we're gathering evidence to show why our client deserves to get a grant in their application. We had mentioned inadmissibility grounds. This is another legal term for immigration purposes. And this just sort of provides an overview of what those inadmissibility grounds are that immigration looks at. And so one of the common ones we'll see is unlawful entries into the United States. That could be something that immigration looks at that could make them inadmissible, or false claims to US citizenship. Now, for any of these, there could potentially be a waiver that's available. Generally, if there is a waiver, it would apply to anyone that's applying. But for purposes of VAWA, you would have to show that there'd be extreme hardship to a US citizen or lawful permanent resident in order to get a waiver. What makes VAWA unique is that if we have a VAWA self-petitioner, that hardship can also be themselves. So as long as they can show that they would suffer hardship, or their children if they were to be removed from the United States. There are sometimes instances also where there might not be a grounds of inadmissibility that applies to a VAWA self-petitioner. But again, that would be something that we would make sure to disclose with any pro bonos. And so next then we'll talk about working with survivors of domestic violence, but I wanted to check if anyone has any questions so far about the family-based petition or VAWA itself. Okay. We can also take I know we were a little bit late, if we can take like a 5-minute break if folks wanted to stretch, or we can maybe allow more room at the end for questions then. Yeah, okay. Yeah, so the question is, in terms of the health related grounds, inadmissibility and what it is, whether it would be like a cancer survivor, or if it's because it would be a burden on the health system. And so Trisha, please feel free to add in. The US is very concerned about what immigrants are bringing into the US. And so many of the health related grounds, when you look at it, the statute, so this INA 212A, it does specifically state like what are they looking for. So in some cases, it could be like an STI, could be a health ground. And there is a component that we'll talk about, mention a little bit later, but if someone's adjusting their status, they have to do a medical exam. And so the doctor is checking off and making sure that they have vaccines and that they don't have any diseases. But if they do, we would have to explain. I think a common one that comes up is tuberculosis is something that comes up a lot. And so then either the non-citizen has to get treatment, or if it's not that serious, then the doctor would sort of say something about like, oh, it's going to be prolonged treatments. Trisha, did you want to add anything to that?
Yeah, so I just put this in the chat for folks online, but US is primarily concerned with communicable diseases or certain, how do they word it here? I want to be physical or mental disorders is what they say. And you can find more information if you're interested in the USCIS policy manual. For example, years ago, HIV was on the list. It no longer is on the list. 2 months ago, there was a requirement that folks needed to get the COVID vaccine before entering the US or being admitted. That is no longer a requirement under this new administration. So I have no idea what kind of changes will be implemented under this administration, but historically, they're looking for things like gonorrhea, TB, tuberculosis, and physical or mental disorders that cause harm to the individual or others.
All right. Any other questions? Okay. Then I'll turn it over to Graciela to talk about working with survivors of domestic violence.
Thank you, Teresa. So you get a little bit of a break now. In this section, we're going to kind of define what domestic violence is, talk about the different manifestations, kind of the cycle of violence that exists, and then the cultural barriers that our clients in particular might face because of their immigrant status. And all of this is in order to help you kind of better understand their lived experiences. So the diagram that we have here is the power and control wheel, which can kind of help us visualize and understand domestic violence and the different forms it takes. So we can define domestic violence as an abuser's ongoing conduct of asserting power and control over another person. And although we often think of this in kind of a romantic context, this person can be a spouse or a partner, but also it can be done to a child, a parent, and it can occur in heterosexual and same-sex relationships. So on this power and control wheel, you kind of see the different forms. While we're pretty familiar with like physical abuse, sexual abuse, emotional abuse, there's also economic abuse, the use of threats or intimidation, isolation, or even the use of citizenship or residency privilege. So I'll go through a few of the examples. So I'll start with the threats side of the wheel. So this can be threatening someone with their immigration status, threatening to report them to ICE, threatening to withdraw petitions that have already been filed. But it can also be threatening someone's family members, their own health and safety, threatening with DCFS or threatening to get someone's kids taken away. And it can also be an abuser using suicide as a tool to manipulate and control by threatening to take their own life. There is intimidation, which can often be physical, but in the immigration context specifically, sometimes that can mean the destruction of civil or legal documents that would be important when someone's pursuing, an immigration matter. There's isolation, which is focused on preventing community interaction. So this can be preventing someone from being in contact with family or friends. It can be preventing them from speaking their native language, but it can also be keeping someone from making new connections, like preventing them from learning English or forming, a new community in the United States. I'll skip over citizenship and residency privilege for a second because there's another slide fully dedicated to that. We have emotional abuse, which can be experienced as playing mind games, gaslighting, using degrading words to make the victim feel less than, and this can include racist or sexually degrading language. There is financial and economic abuse. So in this case, if the abuser knows that their victim is working under the table, as they say, they can threaten to report them for not working with authorization. It can be not allowing them to pursue schooling, for more job training, not allowing them to get a job. But it can also be if their victim does have a job, asking them to turn in their paycheck, handling the finances completely alone, and withholding information. So sexual abuse is, I think, pretty prominent in discussions of domestic violence, but when working with clients, it's important to understand that even if they experience rape or sexual assault, they might not necessarily understand their experiences in that terminology. So that's an instance where language really matters when you're working with clients. Sexual abuse can also include accusations of infidelity, using infidelity to manipulate, calling the victim a prostitute, or even reporting that information on immigration forms. And lastly, physical abuse can include biting, scratching, slapping, punching, kicking. And it's important to remember that sometimes it may not leave marks, and that doesn't necessarily mean that it did not happen. This can also include throwing objects, not even hitting the victim necessarily, but and also the deprivation of food, water, other necessities. So all of these can kind of fit into different stages of the cycle of violence, which is the next slide. So there is kind of a pattern of escalation in terms of these abusive incidents. And oftentimes when clients describe their relationship with the abuser, it will start out healthy, full of affection, kind, and then change gradually. But the timeline on which this changes can be different for everybody. And although these examples are somewhat oriented to romantic relationships, it can be applied to many different types. So definitely ask your client how these events occurred, but in general, we see abusive relationships kind of taking this same cycle. So we can start in the honeymoon phase. This is kind of where a relationship is at its most ideal, its most romantic. This is a stage where maybe gifts are presented and the abuser makes lots of promises, although it eventually leads to tension. So minor incidents of physical and emotional abuse. The victim may try to control the situation, but be unable to. There is a sensation of walking on eggshells, and this is oftentimes the longest phase before an explosion occurs, which is a serious incident of domestic violence in which the abuser seems out of control. This is often the shortest phase, but over the course of a relationship, it often becomes more and more frequent. And then after that phase has completed, the abuser often returns to the same behavior they exhibited at the start of a relationship, asking for forgiveness and apologizing. in order to deny what happened and what may occur again in the future. So this cycle is very necessary in order for the relationship to kind of sustain itself. So there are different cultural barriers facing immigrants. We include this slide for your awareness, but it's also important not to make assumptions. Definitely ask your client about their specific cultural background, their specific family and personal dynamics. But some of the barriers that they may face include language limitations. So it can be very difficult for clients who don't speak English or speak English as a second language to seek out resources, to make new connections, and maybe even to articulate what happened to them. So that is why we also have a handout about working with interpreters if they're needed. Clients can face extreme isolation, oftentimes due to the abuser isolating them, and even due to their language limitations. There can exist cultural ideas of family shame and honor. So maybe this idea that abuse is not spoken about outside the home or outside the community. There are different cultural ideas of what constitutes abuse. So maybe a certain amount of yelling or physical harm is kind of considered to be just part of whatever that relationship may be. So it's important to talk about these things and kind of see what the victim thinks about their own experiences. So there's also some communities where, you know, it's a small community, maybe a very close-knit community, and it can be difficult for a victim to talk about their experiences if their abuser is someone who is held in high esteem and has a good reputation. There's also the role of religion. So maybe sexual abuse can be difficult to report, or maybe the victim feels shame in wanting to seek a divorce. So this goes back to the privilege of citizenship and residency. Immigrants often, especially when we're looking at VAWA cases, their abusive, US citizen or LPR relative may kind of hold that over their head. So that can include behaviors like failing to file immigration papers on their behalf, filing an I-130 family petition and then withdrawing it, threatening to contact immigration officials, contacting immigration officials for the purpose of reporting family members, and providing immigration officials with false information. But this can also include things like withholding documents, and as well as not giving them agency or not allowing them to contact lawyers in their own immigration matters. So I believe that that is the last slide for my section. But if you would like to see more examples and see the diagrams again, they will all be included in the VAWA Pro Bono manual.
Thanks, Graciela. And so this is important for us and for our pro bonos to understand that, especially going into as they accept the case and when they meet with their client. So next we're going to talk about preparing a VAWA case. We'll talk about interviewing the client, what evidence to submit, and then more just about the logistics with the VAWA application. And so when a pro bono accepts the case, they would meet with their client, and it's important for them to enter the space being trauma informed, right? So Graciela explained a little bit about some of the things that our clients have gone through and the reasons perhaps why they've done certain things. So it's important for us to know that. Before anything, we would encourage pro bonos to make sure that they have an interpreter, a volunteer interpreter for any meetings with the client. A lot of our clients don't speak English as their first language. And so it's great if you speak their language, but if not, have a volunteer. And we ask that you not rely on their family members to be the interpreters. So for example, like if we have someone who is the spouse of an abusive US citizen and it's their child that's the interpreter, that sort of also puts this heavy burden on the child. So we wouldn't want to do that. Additionally, you want to make sure that you have a safe way to communicate with the clients. And so sometimes our clients still live with their abuser, so they might not be able to receive mail, or perhaps their abuser controls what they're doing, who they're calling. And so you want to check, like, is this a safe number? When can I call you? Can you receive mail, or what's the best way to get in touch? Generally, we will, if we know that beforehand, we'll make sure to let the pro bonos know, like, just so you know, client said, call after 5. But it's also good for you all to check in with the clients because things change, right? A lot of our clients are also coming in with a lot of other things haven't happened to them. And so we want to make sure that we're building rapport with them and making sure that we're telling them there's this confidentiality we have. We are not going to share this information with anyone else outside from NIJC or and it really does help with building rapport, and it'll allow them to be more open when they're telling you things about their life. If appropriate, you can refer clients to counseling or other services. We would never tell them, like, you have to go to therapy. We would never say that, but we can suggest it. And sometimes our clients might ask, like, do you have any referrals, or do you know where I can go? And so if that happens, you can always reach out to us. We have a list. I believe the list is also on our website with our materials, but if it's not, we'll make sure that it's on there. And then when you meet with your client, you also want to make sure that you have a retainer sign with them. This is a little bit different from the one that NIJC signs. It's just an agreement between the pro bono and the client. And then any release of information forms. That way, if you have to obtain additional records, you have a form signed. But most importantly, the purpose of having these interviews, again, is to build that relationship and trust. And this can look different in various ways. You want to make sure that there's this emotional and physical space with your clients. So if the purpose of the meeting is to do an affidavit, and you know you're going to ask them a lot of difficult questions about the trauma that they experience, what we normally do is say, let them know ahead of time, hey, we're going to talk about this, but at any point, you let me know if you don't want to talk about it anymore. We can take breaks. You can also encourage them to, maybe they want to write it down on their own beforehand and just bring you the copy. Maybe they don't want to verbally tell you about it, but it helps them to write it down. So we want to just meet the client where they're at, right? We need this information, but there's no one right way to how to get it. We want to make sure that we're not using all this technical legal jargon when we're talking to our clients. So for example, that battery and extreme cruelty, that was so much legal jargon. I could not imagine explaining that to my client. It's complicated for me. And so I wouldn't explain it that way, but I would sort of explain it maybe differently. And perhaps this is where using the domestic violence power and control wheel might come in handy to sort of explain or ask, have any of these things happened? Or maybe when the client is telling you about events, you yourself are identifying that is abuse. We want to make sure we're transparent with the client, so letting them know what exactly the process is going to look like. That also helps them build trust with us, because they know, okay, this is important to my attorney, and they have a plan and they know what's going to happen. So we want to tell them, this is what it's going to look like. This is information we need. If there's any fees, we want to tell them ahead of time. And we want to review what any of the documents that they're going to need is. So basically, at your initial meeting, you're going to learn about the client. Perhaps you'll start filling out forms and making any copies of documents. And then you will have follow-up meetings with them as you continue to work on the case. So we'll go a little bit into detail about what each of the different pieces of evidence are. And the affidavit is the first one that we talk about. It really is the strongest piece of evidence. And as we go through the different pieces that you have to submit, you'll see that we're going to say, put it in the affidavit. What's important with this is that this should be written in our client's own voice. I know oftentimes, especially for me, I want to like write it for them. And I think like, I'm going to write it and it's going to be so compelling. But it has to be in our client's voice. We cannot embellish. So when we do that, either the client could write it in their own native language, but then we would have to translate it. Or if they have an interpreter, you can write it in English, but you are required to read it back to the client in their native language to make sure that they agree with what's written, and that everything is correct. And we do have samples of what that looks like when you're filing. Sometimes there's a lot of trauma there, and so perhaps talking to, it would be a good idea to recommend our clients, if they are seeking services or they currently have a domestic violence counselor, they could talk to them and sort of help them with writing this affidavit. But in the affidavit, the essential parts is that we want to make sure that the client's name, date of birth, and place of birth are there. Talk about their immigration history, how they entered, if they've left. They have to talk about the marriage to their abuser, if it's a spousal petition, or the relationship to the abuser, if they're the child or parent of an abuser. And they would talk about any names, dates, places of birth of any children, talk about their life living with the abuser, where they lived, how long they lived there for. Then they would talk about the battery and extreme cruelty. And so here's when we would need sort of examples of what happened, and it would be in chronological order. And so that's sort of on us. So a client might come in and tell us, in 2014, this is what happened. And then you meet with them again and they'll be like, well, actually in 2010, this also happened. So they might not necessarily be telling their story in chronological order, but we want to make sure that when we are helping them with drafting the affidavit, it's in chronological order so that immigration is able to follow along with it. We would talk about any good moral character, so ways that they are involved with their community, or any positive factors about our clients. If there's any negatives, perhaps they had encounters with the police in the past, had any arrests, we would talk about it and sort of explain why that happened, and also just sort of like, this happened, but I'm not a bad person, that was before, and this is how I have changed. We would want that in the affidavit. And then the last thing is, it would have to be signed by the client. We often get the question if a digital signature is enough, but we would say that it has to be the original signature, so wet signature from the client. And again, you'd need a certificate of translation if English is not the primary language of the clients, and if that's not how you all reviewed it. Then the next evidence is identity of the self-petitioner. So again, they have to prove, or sorry, the self-petitioner. So that would be any birth certificate or marriage certificate, anything that shows their name. That would be evidence to prove that. Then they would have to show the immigration status of their abuser. And this is where it can sometimes get a little bit tricky, because this is something that the abuser would control, right? And so sometimes our clients have already left the situation and they maybe don't have access to these documents. So we would help them try to be creative of what they can use. Ideally, if they're a US citizen, they could use a birth certificate, a passport, or a naturalization certificate if that's how they became a citizen. If they're a lawful permanent resident, then perhaps a copy of their legal permanent resident card or green card. If there's any official documents that state what the status is of the abuser, that would count as evidence. Sometimes if we don't have anything, we try to get creative, like if there's any voter registration logs, we might pull that. Sometimes we could get letters from family members or friends that say, like, I know that they were a citizen, or I know that they were a lawful permanent resident, and explain how they knew. So if they were like, I know that they're a US citizen because I went to their oath ceremony, perhaps we could use that as evidence if we have nothing else. So this is sort of where we have to get a little bit creative. But if the abuser obtains status through USCIS, so either they're a lawful permanent resident or they're a naturalized citizen, we could also just ask USCIS to search for their records, because they would have access to that. We would have to also show good faith marriage. So in addition to the client's affidavit, we would need the marriage certificate for them. And if the client was previously married, we would need a divorce certificate also. And this goes to show that it is a legal marriage, that the client was able to enter into this marriage legally. Birth certificates of any children, if they're children in common and have both of their names on it. Any bills or leases that would have both the client and the abuser's name. Sometimes our clients don't have any of that. It is common for the abuser to keep all records in their name as part of the control. So again, trying to get creative of how to get any of this evidence. This can be family letters from family or friends. If they are privy to, if they knew about the abuse, they can write about what they knew. Or if there's any pictures of the client with the abuser, that could also serve. Yes. Yeah, the question is what happens if the abuser does not have the divorce certificate, right?
Yeah,
Yeah.
so like if the, like the marriage wasn't valid because the abuser wasn't actually divorced. And like I'm just imagining like how somebody who doesn't even know that they're not divorced.
Yeah. So we have had pro bonos before where they were somehow able to find the divorce. Because it's going to depend on jurisdiction. Sometimes it is like public information if there's divorce decrees, but that's not always the case. So that's why the affidavit is going to be a really big piece of evidence. So the client would say, like, well, from what I know, this was a legal marriage. This is what happened the day of the marriage. And then also showing that they intended to enter into this marriage in good faith, right? So like they have children together, they built this life, we went on vacation or we, holidays, that's sort of how. But as long as the client intended to be in this good faith marriage, they don't necessarily have to prove in that sense that, like, yeah.
The death, like the divorce certificate are just what
Right. Right. And these are, again, just some ideas. Like if you take a case, you don't have to have every single piece of evidence. This is just some ideas of like how you can demonstrate it. And it's really going to vary. I don't know, maybe you all have had clients that have every single piece of evidence, but it is very rare. So we just try to get creative. Yes.
Kind of going back to the previous slide, I guess, is it often difficult, or does someone often come in and they're not really sure about the immigration status of the abuser, and so if it's just not a U.S. citizen or LPR, then it's not a luck in this situation, I guess.
Yeah, I mean, the question is, if the client doesn't know if the abuser's status was a U.S. citizen or a lawful permanent resident. So on our end, on NIJC's end, we make sure that when we're doing the screening, we're asking all the questions. This training is specifically for VAWA, but there is a separate form of relief called a U visa. And so domestic violence is a qualifying crime for a U visa, and the abuser doesn't have to be a citizen or resident. So that it'd be separate, yeah. So we would screen but it does happen. Sometimes clients will be like, I know that they have status, but I don't know what kind of status they had. And so on our end also, we will do a lot of the heavy lifting of like trying to see, well, like, how can we figure out what their status is? So we might look at the voter registration, like, did they register? It just sort of depends. Like we might have to ask clients more questions, but that's a good question. All right. There is a requirement also to show that the client lived with their abuser. And so a lot of the evidence is sort of going to be repetitive in the sense that it proves multiple things. So again, joint residence, any male that has both of their names, again, that might not be feasible. So if that's the case, then any letters from family or friends that can say like, yeah, we live together. If they have children, maybe the school records would show the address. It just sort of depends. Then we have to show that the client currently lives in the United States. And so we would ask them, again, similarly, any bills in their name, rent receipts, any IDs with their address, or letters from family or friends. And good moral character, sort of the same. I mean, you would use an affidavit. I think one difference with good moral character, there is, our clients can get a local police clearance letter from any jurisdiction where they're living, as long as they're living there for at least 6 months or more, then they're able to get this letter from the police, and it would show that there's no criminal history. And we often use those letters with our evidence too. It's not required, and so don't feel pressure like, oh, I have to get this police clearance letter from my client. But if you have it, it would be a good piece of evidence. And if the client has any criminal history, we would need certified dispositions for all arrests to be included with the good moral character aspect. Then we have the battery and extreme cruelty portion. So in addition to the affidavit, so that's where the client's going to really talk about the abuse that they suffered. But also if there's any police report, so if the client ever called the police on their abuser, then we would want to get copies of those reports. If the abuser has ever been arrested, we might want to try to see if you can get any certified dispositions. If there's orders of protections in place, we can also include those. If our client ever had to get medical treatment due to any of the incidents of abuse, that's also a piece of evidence that can be used. We'll also ask for letters from any domestic violence counselors or perhaps shelters, and then also letters from family or friends. Any questions before going into the filing procedures and more of just the logistics? I know this is a lot of information. This is recorded, and so it will be on our website, and we also have materials on there. All right.
I'm just gonna mention one of the questions that came up online here. Somebody asked, in the end, when applying for adjustment of status, does the victim have to be separated or divorced? And that is not a requirement. So, as Teresa mentioned, it's possible to be divorced, but it is absolutely not a requirement. So, if your client is still married to their abuser and even living with the abuser, that is, there's no requirement that they be separated or divorced. I think what you want to do is kind of try to look at the case from the eyes of an immigration officer and maybe just look to see if there are any concerns with fraud, right? We're going to be screening for all of that up front. By the time the case gets to you, I would expect there will be no fraud concerns. But that's one thing that we just have to advise the clients on, not because we don't believe them, but because we also have to play this role, looking at it from the eyes of immigration.
All right. So we'll just talk a little bit about what the filing procedure looks like. So you've accepted this case and you're ready to file. So there's sort of two separate aspects. There's the VAWA self-petition. And so that is where you have all your detailed arguments. You'll put it in the cover letter and have an index of exhibits for all the documents. We have samples, and if someone takes a case, Graciela will put together a packet and give more guidance and information of where to find samples. So you don't have to feel like you're inventing this out of nowhere. There's also a G28 form that has to go with the application. That's just your notice of representation indicating you're the attorney. And then the actual form I-360. So that is one process in itself. If the client is able to adjust, then that application might be filed at the same time. It will just sort of depend, but you should consider it almost like its own separate packet. So you'll do another cover letter with the detailed arguments, with your index, file the G28 also, and you have to file form I-485, that's the adjustment of status. But this is only, again, only if they are eligible. Then we have the requirements of the 2 passport photos, There's a medical exam that they'll have to do, and then they can do the application for employment authorization when they're filing their adjustment of status. We would just really emphasize to make sure that you're always checking for the latest forms. Recently, they just updated the forms, and we didn't have notice. So just make sure that if you take a case, you're double checking straight from the USCIS website to make sure that the application is current. And one change with the VAWA I-360 is that there is a question now that you can just mark and it'll ask, like, if you want to apply for employment authorization with this application, you would just mark it. So you don't have to file a separate employment I-765. But that's only if you're just doing the VAWA, not the adjustment of status portion. Because this is a application that's based on being a victim of or survivor of domestic violence, there's no fees that are associated with it. So we can go to the next slide. We will always update though pro bonos if there's any changes, and we do try to update if there's any changes to the forms too. But yeah. So just some tips to filing. Make sure that everything is translated. It can be in its original language, but it has to be translated. The application itself has to be 2-hole punch at the top. We really ask not use a spiral binding, and the reason is because immigration will scan the documents, and with the spiraling, having to take that off, they really don't like that. So just do 2-hole punch at the top. Don't use any tabs on the side. Again, they do not like taking that off, but we do encourage you to put page numbers on the bottom. I already mentioned the updated forms. So if the client is doing both the VAWA and the adjustment of status, you should prepare them like 2 separate documents. And the reason is that together you are going to file them to the same place. The first step is that the VAWA has to get approved. And normally when that's approved, the I-485 goes to a different processing center. So that's why we want to keep them separate, but they can go in the same packet. Perhaps maybe put them in 2 different envelopes, but that's just to make sure that everything goes to where it needs to go. And we encourage folks to use FedEx or any trackable delivery service, just because we know that with the mail, things get lost. And so we want to make sure that the application gets there. Next is just where to file. This will all be on our website also and in our materials. And just case processing. So after an application is filed, you should receive a receipt notice indicating that they received the application. They'll assign a receipt number, and that would be the number that you would refer to if you ever have to communicate with immigration about the case. Here we have approximately 4 to 6 weeks is what it's taking to get the receipt. I think, speaking with other colleagues though, lately we've seen that it's taking a little bit longer. So if you have concerns like it's been months, I have nothing, please reach out to us. And we can that's sort of part of the technical assistance that we can provide. Then you would get a notice indicating that maybe if a prima facie determination is made, you might receive a notice. That could be several months after filing the petition. But just so you all know, and so you can relate to the clients, currently USCIS is taking about 3 years to process this application. That could change, but right now that's approximately how long it's taking. Prima facie notice. This doesn't mean that the case was approved, but if a client gets that, it is a good sign then of the application. And with it, they could potentially obtain certain public benefits. It just depends on where they live. In terms of outcomes for a case, ideally, your case is going to get approved, but there are other scenarios that could arise. You could get a request for evidence. That just means that USCIS wants additional evidence. Perhaps they're not satisfied with what we submitted for good moral character and they might ask for more. So they will send you a notice directly to the attorney, and they'll put a deadline. And so if you receive a request for evidence or notice of intent to deny, or even a denial, well, any of these actually, we would ask you to reach out to NIJC. But I think it is more important also for if you get a request for evidence or notice of intent to deny, that way we can help walk you through it. Like, how can you respond? And if there's any additional questions. When the VAWA application is approved, the client would get deferred action, so low priority for removal. If there's derivatives on there, their derivatives would have to file for this deferred action separately. Initially, deferred action is valid for 15 months, and then they can renew it in 12-month increments. And that's something that if you have a client, you can talk to us and maybe we help with that, or if you all want to stay on the case, you could do that. They'd get work authorization, and then depending again on their immigration history or criminal history, they might be able to file the adjustment of status application. The employment authorization, just touching briefly on that, allows our clients to work, and there's various different categories of how they'd be eligible. For the adjustment of status portion, again, we would help determine if the client's eligible, but if they are, they might have an interview. The purpose of this interview is just for the immigration officer to adjudicate that specific process, the adjustment process, but they should not be re-adjudicating the VAWA claim or questioning the validity of the decision. And if they have an interview, you'd bring all the original documents. You'd have to bring an interpreter, and yeah, this is just some documents that you would have to bring, but we also would let you all know too. Again, just make sure that you keep in touch with your client even after filing. 3 years is a long time. Clients are probably going to move. We want to make sure that you have the correct address. We are required to let immigration know of any change of address, both as our own address too. So we would want to let them know if the client moves, but we also have to let them know if like the law firm moves. And this is guidance that NIJC can provide also. We are not going to have time to go through case samples, but we have a list of resources. We'll, I think we shared the link already to our website where we have a lot of the materials posted, and it's also in the handout today. But I want to make sure that we get the CLE code. If anyone is interested in any pro bono cases, definitely we have our contact information in the materials. We have various projects, so the VAWA project is not the only one. So if you're interested, you can reach out to Charlotte. She can share information. And then, yes.